Thank you. You may be seated. We're here on State of New Mexico versus Keith Sandy, CR 2015-104, and State of New Mexico versus Dominique Perez, CR 2015-105. Entries, please.
Good morning, Your Honor. Randy McGinn, Alicia Montoya, and Mike Sievers on behalf of the State of New Mexico.
Good morning.
Your Honor, good morning. Sam Bregman, Monica Garcia on behalf of Keith Sandy, who's present at court this morning.
Good morning.
Good morning, Your Honor. Luis Rose, Nick Avia, and David Rowan on behalf of Dominique Perez, who is in the courtroom today.
Good morning. I understand we have our technical problem repaired.
Yes, Your Honor.
Okay.
It seems to be working.
Okay.
Thank you.
Just a quick reminder again to people in the audience that there is a decorum order. I understand that it might be inconvenient for some of you, but it really is to make sure that the jury is able to focus on the evidence that's presented without any distractions or as little distractions as possible. So please don't come in or out of the courtroom unless we take a recess. I'll have them announce in the hall when we're going to reconvene so you have an opportunity to get back into the courtroom. Was there anything you wanted to address before the jury comes in?
Nothing from the State, Your Honor.
No, Your Honor.
No.
Okay. They're on their way up. It might just be a couple of minutes. Ms. McGinn, do you want to bring in your witness since we're going to continue?
That'd be fine.
Good morning.
Good morning, Your Honor.
When the jury comes in, I'll swear you in again for today. Okay.
If there's a document up, you should be able to just touch it. If you click witness up there on your device, that the witness should be able to touch it. Can we try that? Or you have to. All right. Might not work because we don't have anything on the screen yet. No, it's not having a signal. It's thinking about it.
Who are you on Instagram? Me.
You should be able just to touch it with a picture comes out. Do you have a test page that you can put on the computer screen?
Let's try with the elbow, Your Honor. That would be great.
So we press Elmo.
Well, he said BG.
That's our computer. There you go. That's our computer.
Okay.
That's fine.
And
That you can draw on that, Lisa. That'd be fine.
It hurts. And then to erase it, I think you double click. Oops. No, maybe down here somewhere.
You know, they show us how it is.
No.
They didn't show us how to write. Okay. Please stand. Thank you. You may be seated. Good morning, ladies and gentlemen. Please raise your right hand. Do you swear or affirm to tell the truth and nothing but the truth under penalty of law?
I do.
Thank you. You may be seated. Again, please state your name for the record.
Jeff Noble, NOBLE.
Thank you. You may proceed, Ms. McGinn.
Mr. Noble, I forgot to admit your resume yesterday, so can I hand you State's Exhibit 58A, and can you tell the jury what that is, please, sir?
This is a copy of my resume.
Your Honor, I move 58A into evidence.
Any objection?
Yes, Your Honor, we object. It's redundant, it's repetitive. He's here to testify. He can tell the jury himself what his qualifications are. It's also hearsay.
Objection, hearsay.
Any response?
It's not a hearsay document, Your Honor, it is just being offered. Well, it's being offered to show the truth of the matter, sir, I take that back, but I think it is helpful to the jury. I don't think it's the kind of hearsay that is unreliable. I think it just goes through all his education and saves time for the jury, so I don't have to go through all these things like myself and talk about all his qualifications and all the places he's testified.
Sure. I understand that might be more convenient and less time-consuming, but since there's a hearsay objection, it doesn't seem to be an exception. I'm going to sustain the objection. What number was that?
This was 58A, Your Honor. Let me start with a question that got left off at the end of the day yesterday about the SOPs and the standards in the SOPs that we talked about yesterday. Can you tell the jury whether those are rules or guidelines or just mere suggestions for police officers?
Those are rules. Officers are held accountable to the policies, and they can be disciplined and be held accountable for violation of those rules.
And are those rules in the SOPs, are those civil cases or for criminal cases like this one?
Generally for civil cases.
All right. And who will instruct the jury in this case on what the law is in the criminal case?
Objection, Your Honor. She's asking this witness for legal opinion. This is improper.
Same objection.
Well, he is a lawyer, Judge, even though he doesn't practice. But in fact, I'm asking him about whether he is the appropriate person or whether the court is the appropriate person to instruct on that issue.
I am the appropriate person.
Okay.
And
Then
I'm
I'll
going to
take that.
sustain the objection.
Okay, thank you, Judge. Let me ask you a hypothetical question. Assuming that the New Mexico criminal law says that you can't start the fight yourself and then claim self-defense, does that concept make sense to you?
Objection, Your Honor. Calls for a legal conclusion. It's improper.
Same objection.
Sustained.
May we approach, Your Honor?
Sure.
Okay. Let's talk about the SOPs that we were talking about yesterday about not escalating the encounter so that you have to use force. And let me ask you, do you have an opinion about whether at the time that James Boyd was shot on March 16th of 2014, about who was attacking who at that moment.
Yes.
Can you tell the jury what your opinion is, please?
It's my opinion that the officers, through use of their reckless planning, were moving toward and attacking Mr. Boyd.
Was that in violation of their standard operating procedures and their training?
Yes.
Once you start doing something reckless or against your SOPs, is there anything that prevents you from stopping your actions?
No.
And were there various points during this attack on Mr. Boyd that they could have stopped?
Oh, yes.
What points, if you can tell the jury, what points during that, leading up to the time where they began shooting, what points could they have stopped this encounter?
Officer Sandy threw the flashbang. It didn't work. They could have stopped. Supposedly there's a layered plan. There was an opportunity to surrender during each period. There was no meaningful opportunity. They've used the taser shotgun. It didn't work. They could have stopped. They sent the dog up. It didn't work. They could have stopped and called the dog back. So at each step during the course of their plan, when nothing was working, they could have stopped at each point and regrouped and come up with a new plan.
And how could they have made themselves safe from any attack by Mr. Boyd?
By maintaining their distance, by either, if they did move up, to move back, but to maintain distance.
When Mr. Boyd said he was going to come down and picked up his bags on the videotape, did he express any concern that the officers were not going to keep their word to him as he was coming down?
Yes.
Okay. Well, what I'd like to do now, Judge, if that's all right, is, what I'd like to do is play 9C2, which is the videotape of the encounter, and let me ask you, Mr. Noble, have you reviewed the videotape from Defendant Perez's helmet camera?
Yes, I have.
And have you reviewed it both regular speed and in slow motion?
Yes, I have.
And have you reviewed this particular exhibit? Tell me the 9C2. 9C2?
Yes, I have.
Okay. What I'd like you to do, Mr. Noble, first I'd move 9C2, Your Honor, into evidence.
Any objection?
Is that the CD that was just given to us this morning?
No, it is not.
Is it different?
Different one.
Okay. Just my understanding is this is just the audio or the video?
It's the helmet cam video and audio of the helmet cam of Defendant Perez.
I don't have that.
Okay.
No objection.
Okay, 9C2 will be admitted without objection.
And I will need some help with this.
Okay.
Mr. Noble, what I'd like to do is go through this frame by frame up into the point where Mr. Boyd starts to turn and shot, and walk through, and if you can show the jury at which points they could have stopped, backed up, made themselves safe, and not escalated this encounter. Okay? And if you can tell Mr. Sievers, who has said he will stop whenever you tell him to stop, and then you can draw on the screen. Okay? And first of all, I could find a different line. You find a different line. There you go. You got the wrong line. Okay?
This is 9C2?
No, we want to start from the very beginning.
Oh, you do? Okay.
Yeah. Okay, can you stop that just for a second? Can you tell the jury what Mr. Boyd does at the very beginning of this encounter and what he says? As far as him picking up his bags.
I can't recall exactly. You need to stay by your word.
Your Honor, I'm going to object to him just speculating. He says he can't recall.
Okay.
Just-
Mike, does this have sound?
Yes.
Okay, all right, thanks. Okay. What does he, how far does he get before they begin to implement their plan, that is the throwing of the flashbang?
Just a few feet.
Okay. So can you go ahead, Mike, and advance that?
You can stop.
Can you talk to the jury about that?
Yeah, at this point,
Actually, the form of the question, talk to the jury about that.
Be glad to ask another question, Jeff. Can you tell the jury about what's significant about this moment when the flashbang goes off? And first, why don't we start with explain how a flashbang works?
a flashbang is what we call a noise light diversionary device. It's in a metal canister. It's sort of like a grenade. It has you pull a pin and it has a handle on it. When you toss it, the handle lifts up, activating the device. It doesn't go off for a couple of seconds, and then when it does explode and when it ignites, it sends off a very, very bright light. It makes a very loud sound, like an M80, but even louder if you're, a loud firecracker. And it does have a little bit of a concussion. It sends off a little concussive wave. If we threw a flashbang into this large courtroom, we would all feel it. You would feel the wave. You would be impacted by the sound. If we threw it where it's typically used in an entry into a residence, into particularly a bedroom, you would really feel it. The smaller the room, the confined space with the walls, the ceiling, the bigger the impact. When you throw it into an open space, particularly if there's some distance, that impact dissipates because of the open space. There's no opportunity for the concussion or the noise to bounce off the walls. You have a different type of impact. So in this case, they're throwing it in an open space. He threw it close to where Mr. Boyd was at, but it hit a rock.
I'm objecting to non-responsive. The question was explain what a flashbang is.
Sustained.
Okay, I'll be glad to ask you another question. Can you please tell the jury what happened here and why it didn't work the way it was supposed to work in this open space area?
It didn't. What happened here is they threw it and it hit a rock. It bounced off. It bounced away from Mr. Boyd. It's in an open space, so you don't have that same kind of impact that you would have in an enclosed environment. And you can tell the impact. Mr. Boyd just stands there, which, I've been around dozens and dozens of these flashbangs as they go off, and I will tell you they definitely will have an impact on you if you're in a closed space.
This is non-responsive as well. What he was not.
Sustained.
Sure. You've been around these yourself, have you?
Yes.
Okay. Should their training have told them, or should they have known from their training, that using a flashbang in an open space like this might not have the same effect as if you dropped it in a room like this courtroom?
Yes.
And should that have been part of a plan that what we do if the flashbang doesn't work?
Yes.
So, and from this moment on, does Mr. Boyd ever move towards the officers after the flashbang is hit? Does he ever move towards them?
No, I don't see any movement in the video.
All right. Who moves towards who for the rest of this video?
The officers are moving toward Mr. Boyd.
Okay. Why is this point in time significant when there is a flashbang and it has no apparent reaction to Mr. Boyd, as far as what the officers should have done?
Because this was the first step in their plan. They believed that this flashbang would disorient Mr. Boyd in some manner and allow them to proceed with their plan. Either he would give up or they would move on to the next steps. It didn't work, so this was an opportunity for them to stop, regroup, and redevelop a new plan.
Okay, and they did not?
They did not.
Okay, can we go ahead a little bit further?
Sure.
Okay.
You can stop.
And we heard something go off. We heard something go off. That wasn't a gunshot, was it? What was that noise that went off there?
Objection leading, Your Honor.
I'll rephrase it. What was that noise that we heard?
That was the taser shotgun being deployed.
Okay, and can you show the jury on the screen there, maybe drawing it where the taser shotgun is?
It's up in this corner.
Okay. How do you know that's a taser shotgun rather than a rifle? Because to us lay people, it looks like a rifle or a shotgun.
The foregrip is painted yellow to identify it as a less lethal device, so you don't make a mistake. So you don't accidentally grab a shotgun that would have a live round in it.
All right. And what happens when this taser, can you tell the jury, first of all, how the taser shotgun works?
It would appear like a regular shotgun shell, except it's clear. You can see through it, intentionally so you know that when you're loading it, that in fact it's a taser round, not a live round. When you fire that round, a device comes out of the shotgun barrel. Whether or not the barrel has grooves in it, it will still create a spin, or whether it's a smoothbore barrel. The device has the ability to create its own spin, so it's a very accurate device. And from there it expands, so some probes come out. It's a self-contained taser that will automatically activate for 20 seconds. So you'll have 20 seconds of where the taser is impacting. And for it to work, the probes actually have to make contact with the skin. Sometimes if you have light clothing on, it hits the clothing, you can still get what we call neuromuscular incapacitation. And that's the goal of a taser. It's not pain, it's neuromuscular incapacitation, where you are physically not able to control your muscles, and that'll cause you to fall down and not be able to fight.
Okay, and for Mr. Boyd, who had on layers of clothing in it,
Objection to the questions where she testifies and gives facts as part of the question.
let me rephrase, Your Honor. Was there something about Mr. Boyd's clothing that may have caused this knot to make contact with his skin and to work the way it was supposed to?
Yes, he put on a sweatshirt, and by having either heavier clothing or sweatshirts, that sometimes the taser probes won't make contact with the skin.
Okay, and were the officers aware, and did they see him put on the sweatshirt when he was?
Objection calls for speculation.
Sustained.
Did the putting on of the sweatshirt happen while the officers were present there at the scene and watching him?
Yes.
Objections, the last part calls for speculation and watching.
Sustained.
So, was this something that was a surprise that it might not work, or something that they talked about and anticipated might happen?
No, it's something they talked
Also
about.
calls for speculation, Your Honor. Was this a surprise?
Rephrase that, please.
Yes. Was this something that they anticipated might happen?
Objection calls for speculation.
Sustained.
Let me ask you the basis for that. You reviewed the transcript of the, both the transcript and the audio tape of the conversation between K-9 Officer Weimerskirch, Defendant Sandy, and Mr. Ingram. Is that right?
Yes.
Okay. Can you tell the jury what they talked about as far as the possibility of the taser not working on Mr. Boyd?
Your Honor, I'm going to object based on lack of foundation. He's already testified, he doesn't know who was saying what.
I don't think that's the question as to who said what. I'm going to overrule that objection.
Right.
There was a conversation where there was a concern that if the taser didn't work, the dog may not engage.
All right. And so what happened when they shot him with the taser?
It didn't work.
All right. Can you explain why, if they knew, well, do you understand why it is that they thought the dog might not engage if the taser, if he got hit with the taser and it didn't work? What would be the mechanism that would cause the dog not to engage?
Because the mechanism is still going to be activated for 20 seconds, then the dog may come into impact with the wires.
All right. And what reaction would the dog have if it came into impact with the wires that were activated?
Objection calls for speculation. He's already testified, he doesn't know anything about K-9s.
Let me rephrase the question. What concerns did these three that were talking have about what would happen if the dog came in contact with the wires?
That it may impact the dog as it would impact a person who's...
Objection. He's now, if he's saying that it's a fact, that he said that it may impact the dog like it may impact a person, I just want to make sure that he's saying that that's what the transcript...
Judge, can we not have speaking objections?
Yes.
All right, I'll just object based on lack of foundation. Let me say that.
My question was about the concerns that these officers had talked about what would happen if the dog came in contact with
The witness may testify with regard to what he heard in this piece of evidence he reviewed.
They were concerned that the dog would not engage because of the if the taser wasn't effective.
And you used a police term, dog engaging. What does that mean?
It wouldn't bite.
Okay. What was your understanding about whether they were going to send, in this discussion, going to send the taser and the dog at the same time?
They weren't.
Okay. So how did it happen that the taser got sent and the dog got sent at the same time?
Weimerskirch released his dog.
All right. And so when they shot him with the taser and there was, does he have any reaction to the taser in the video when he gets hit with the taser?
Not that I see.
All right. When he had no reaction to the taser, what could they have done at that point?
They could have stopped.
Right? And did they stop?
No.
Okay. Can we go forward from here?
Sure.
Can we stop for a second? You see the dog run up to Mr. Boyd and Mr. Boyd put his hand out? Do you know if that dog ever bit Mr. Boyd?
My understanding is the dog did not bite him.
Okay. And why do you think the dog turned around and came back and didn't bite Mr. Boyd?
I have no idea.
Okay, all right, let's go on from there. And you can see the dog, you can stop for a second.
Can I just state an objection? I object to the noise, the sound of this, because it's distortion, it has no value. And I don't know why we're playing that sound at the same time.
Any opposition just playing this section without sound?
Yes, Judge, I do have opposition because you can hear the shots on this as well. So the ambient noise is important to knowing what's going on at the particular time.
Okay, overruled.
All right. So in this side.
Just playing this section without sound?
Yes, Judge, I do have opposition because you can hear the shots on this as well. So the ambient noise is important to knowing what's going on at the particular time.
Okay, overruled.
All right. So in this side.
Just playing this section without sound?
Yes, Judge, I do have opposition because you can hear the shots on this as well. So the ambient noise is important to knowing what's going on at the particular time.
Okay, overruled.
All right. So in this side. And how did Defendant Sandy describe that in the statement?
As defensive.
Why is the word defensive important?
Because defensive tells me that he was defending himself from the dog or holding back, defending himself from somebody coming forward, but he's not offensive. He's not moving toward anybody.
And then from here, he puts his hands back down and he says something to the officers. Well, first of all, we hear this officer saying something. What are the officers saying to him while this is going on?
They say, get down 4 times.
Get on the ground?
Get on the ground.
Okay. And do you have any criticism of the officers for saying get on the ground versus drop the knife?
No, I think either way. I think that, you're giving him directions. I don't have any concern with that.
Okay. And the direction they were giving was for him to,
Objection, leading.
Sustained.
what was the direction they were giving him to?
Get on the ground.
All right. And then, if you can move a little bit forward, Mike. Okay, stop right there, please. Okay. When the dog came back, what could they have done?
They could have retreated. They could have stopped, retreated, created distance, recognized that the 3 options in their plan didn't work.
And what decision did they make instead?
To continue forward.
Before we watch the second part of this video, I want to talk to you about another SOP and your training in that particular SOP, their training in this particular SOP. Let me pull it up here. And I think the jury's already heard about this several times, so I won't put it back up on the board and remove Mike. This is SOP 252.3F that says once control of a combative subject is gained and there is no longer an objectively reasonable threat, strikes, blows, or other tools is considered excessive and will no longer be tolerated. Can you explain what that SOP means that police officers should do if somebody surrenders, for example?
If somebody surrenders, they shouldn't be using any additional force because force would be unnecessary.
Okay. And at the time, were these officers trained in a particular technique called the reactive control model?
Yes.
Did you hear Chief Eaton talk about that was the model they were using at the time that Mr. Boyd was shot?
Yes.
I might not have been that one, so I have to put this up instead of that. Scoot that over and we can change it to Elmo, Judge. Your Honor, let me hand you some mark that states Exhibit 59. And is this the reactive control model chart that was in effect at the time of this shooting?
Yes.
Your Honor, I move states 59.
Any objection to 59?
No, Your Honor. If that's the reactive control.
It is.
It is.
Mr. Robles?
No objection.
59 is admitted without objection.
Can you put this up here for the jury? And can you explain how this chart was used to tell police officers what they should be doing and how they should respond to various kinds of threats?
What a reactive control model or other models that are used in policing do is they help police officers make assessments. It's a training tool. This combined with policy and training help police officers make decisions in the field as to the level of force based on the behavior of the individual that they're contacting.
Okay, Judge, can you hit that again because we've lost it? Okay, there you go. All right. And does it put pretty clear-cut lines for them so that they know what to do in particular circumstances?
Yes.
And Judge, this one is blinking on and off, but I think, there you go.
It must be the wires to it because...
All right, I'll try not to touch anything. Okay. And can you explain how this works as far as how police officers should respond? And you can point on there if you need to direct the jury.
Well, it begins with a cooperative subject, and if they're compliant, they're responsive, they're following directions. That your officer's response would simply be able to use their command presence, their authority, and talk to them, and they're being compliant. These are these at the bottom are the kinds of responses that you can apply to somebody who's cooperative. And then it follows up if you're being non-cooperative. If they are resistive verbally, they're saying, no, I'm not going to go with you. No, you're not going to put handcuffs on me. No, I don't want to go to jail. Or they pull or try and run away. In this category, then similarly they offer the control methods.
And let me stop you there because are officers trained in how to physically control somebody?
Yes.
And take down techniques and how to protect themselves from people who are being physically abusive with them?
Yes.
Okay. And then what is the next category?
The next categories go to an unarmed assailant, somebody who is actually threatening or attacking without using any weapons.
Okay, and what kinds of force can you use in those circumstances?
So again, the force matrix is broken up into if they're simply threatening or if they're actually attacking. If they're threatening, then you can use a show of force. You can display weapons. Again, you would still want to use tactics, command presence, and commands. And then if they are actually attacking you, you may use a baton, a taser, or some other less lethal type implement.
Okay, but if somebody is unarmed, you can't use a lethal implement.
Objection leading.
Sustained.
What are you able to do if a person is unarmed as far as using lethal force?
If they're unarmed, you cannot use lethal force.
Okay.
I mean, if they're unarmed and they're not an immediate threat to your of death or serious bodily injury.
Right, and I guess the rules change if, for example, somebody's a martial arts master and can kill you. That may change the dynamic as well. Is that right?
Objection leading.
Sustained.
Are there circumstances under which a person who is unarmed might actually be a physical threat to the person?
There could be circumstances, and those, the officers are trained to evaluate those.
Okay. And in this particular circumstance, even though Mr. Boyd sometimes said he could take them on, was there,
Objection to the attorney testifying before the question.
is there any evidence in this case, Mr. Noble, that Mr. Boyd had any kind of high level of training, martial arts training, anything like that?
There's no evidence of that, no.
Okay. And then let's go to the last category where there's an armed assailant. And tell me where the line is for an armed assailant.
So under armed assailant, you have somebody who is armed and threatening, and then you have this clear dividing line between what you can do for somebody who is armed and threatening versus somebody who is armed and actually engaging in an attack. So if they're armed and threatening, and the colors are important. Red, this is your highest level of alert. This is the area where you're at the highest risk. So you want to employ more options as you move up the chart, where somebody is cooperative, one officer can handle it, or maybe two officers. But as you move up the chart, if you have the officers and if you have the time, you're going to be more resources toward this red category because of the risk imposed. So if somebody's armed and threatening, you're going to want to create a show of force. You'll display weapons. You may tell the individual that you're going to use weapons. If they do certain things, that you're going to tase them or use a beanbag shotgun on them or some other device.
Okay. Which category do you place Mr. Boyd in on this chart?
Mr. Boyd was armed and threatening.
Okay. And at what point was he armed and threatening?
Pretty much from the point where the open space officers initially contacted him.
Okay, and so it was before he actually pulled out his knives in response to the dogs?
Objection leading.
Do you think that he was armed and threatening even before he pulled out the knives in response to the dogs?
Oh, yes.
Okay. And so is there anything about that act that made them able to go beyond the line and use deadly force?
No.
Oh, all right. How firm is this line?
Oh, it's a solid line. I mean, it's firm. I mean, if you go beyond this without having an immediate threat, I mean, that attack, deadly force is not justified.
Okay. Did Mr. Boyd ever attack these officers?
No.
All right. Now, if we can come back up, Mike, and let's put the other one on back again. And I want to let me draw on you. You've drawn on this exhibit, and what I'd like to do is just make a line where you've made the same line, that yellow line here. All right, you can put that back there.
I'm not sure, was that a question, John? I didn't know.
I'm just putting it on there for the record check. But he put a yellow line on this, and I took a black marker and just put that line on the reactive force models for the exhibit.
For the exhibit that you're actually going to put into evidence.
That's correct.
That was
I would
it.
object to that not being proper, because that's not the exhibit that I stipulated to, Your Honor. Not with a solid line, it's a dotted line, that's the exhibit.
Well, Judge, I think I'm trying to replicate what he did that is impermanent, to have a permanent record for the program.
His testimony indicated his position on the line. The exhibit as it was originally offered will be what is admitted.
Okay, well, I'll have to get another one.
Okay.
Okay. You had heard in the opening statement about somebody lunging, that Mr. Boyd lunged. Did that ever happen on this video?
No, I never saw that.
Yeah, heard somebody say he took a step toward the officers? Is that
I-
background the statement?
No.
Let's run through it and let's, first of all, what did you see him do in response to the officers telling him to get on the ground?
I saw his, initially his head turning to the left, followed by his body turning to the left and appeared like he was going toward the ground.
Okay. Can we go through and can you point that out to the jury, please, sir?
Right there, his head's moving?
Yes? And do you see any lunge there?
No.
Do you see any step forward?
No.
What is he doing in that particular slide right there?
Again, his head has gone to the left, his upper right shoulder has gone slightly to the left. He's looking down toward the ground.
Is there any difficulty when you tell somebody to lay on the ground if they are standing on a slope, as far as whether they can lay down the slope?
There may be, depending on the circumstances.
Okay. Can you continue on from there, Mr. Stevenson? Right there, please. Did Defendant Sandy indicate in his statement whether he saw Mr. Boyd turn before he fired?
Yes.
What did he say about that?
He said he saw him turning to his left before he fired.
And despite that, what did Defendant Sandy decide to do?
He fired.
All right. And then he said, and how many times did Defendant Sandy fire?
3 times.
And before the third time he fired, what did he say that he saw before he fired the third shot?
I can't recall his exact words.
Okay.
I'm sorry.
We'll get that record into the jury. You also heard an opening, the defense lawyers say that he wasn't turning and laying on the ground, that he turned and then sort of got blown to the ground somehow. Can you talk about that particular theory in this particular case, about whether that's what's really happening?
Well, I don't see any evidence of that. You don't see any evidence if, in fact, he were blown. You would see his, he was shot in the left arm first and then the right arm. You don't see any movement. And, you know, it's really, we teach our officers basic physics that an equal and opposite reaction. So if the round were strong enough to actually move a body, it's not like television where somebody gets hit by a bullet and they're picked up and moved some distance. You know, so if it had the kinetic energy to move a body, then the same kinetic energy would be applied to the officer, and you see the officer who was shooting move back a distance. So that just doesn't happen.
Okay, and through physics, if he were hit and blown over, how would you expect him, this video to look?
Again, you know, instead of seeing...
Mostly speculation. And he's not an expert at that.
Sustained on that second objection.
All right. Do you see any evidence that he was blown down rather than he was turning and laying on the ground?
I don't see any evidence.
Okay. Can you go through and finish that? Did Defendant Perez start his shots?
As Mr. Boyd was going to the ground, his back had been turned and he was going down toward the ground.
And had Defendant Sandy finished firing his 3 shots before Defendant Perez started his first?
Yes.
Do you have an opinion based on the APD SOPs and their training whether Mr. Boyd was an imminent risk to any of these officers at the time of the shot?
Yes.
And can you tell the jury what your opinion is?
I don't believe that Mr. Boyd was an immediate threat to the officers because he didn't make any movement to begin an attack of the officers.
And based on their own reactive control model, did they cross the line or violate that particular reactive control model?
Objection, Your Honor, leading and stating facts before the question.
The way it was asked, I'm going to sustain the leading objection.
Did they violate their training on the reactive control model in how they shot Mr. Boyd and why they shot Mr. Boyd?
Yes.
Can you tell the jury why they violated their own training shooting Mr. Boyd?
Because there wasn't an immediate threat. The immediate threat is, again, all those factors that we have on Mr. Boyd, that he committed an aggravated assault, that he threatened the officers numerous times, that he was armed with knives, that he was schizophrenic, that the officers knew he was schizophrenic. All those factors combined put the officers up into that red zone, put them into an area where they recognize a very serious risk, and they are trying to deal with that risk in an appropriate way by calling extra resources and extra tools. But the key factor of whether or not you can use deadly force, the main factor is whether or not there's an immediate threat to the officers or to others. And if there's no immediate threat, then that you can't use deadly force.
And in this case, was there an attack by Mr. Boyd?
No.
Do you believe and have an opinion about whether the actions of these police officers were reasonable or unreasonable?
Yes.
What is your opinion about that?
It's my opinion that their actions were unreasonable in using deadly force.
You have it, Your Honor. I want to ask you about why we should care, or why it should matter that James Boyd was killed.
Objection. Relevance, Your Honor.
Sustained.
Was there a time in the history of policing where our society encouraged or supported police officers when they wanted to kill or sweep up people that they thought were undesirable?
Your Honor, objection. Relevance argumentative.
Or 140.
Sustained.
What model of policing do you support as far as dealing with people who are mentally ill or homeless?
Objection. Relevance.
Or 140.
Sustained.
Who makes the decision about whether people are undesirable and should be shot?
Objection. Relevance. Can we approach, Your Honor?
Yes, and
Thank you.
sustained. So, ladies and gentlemen, I just want to remind you of a prior instruction that I had given. The question is not evidence. I'm going to ask that you disregard the questions that I've sustained the objection on, as it's just a question, it is not evidence, and you're to disregard the questions. You may proceed.
Mr. Noble, in the investigations that you've done into other police officer-involved shootings, how do you go about determining what the officer's intent was at the moment of the shooting?
Objection. Relevance.
Or 140.
I think it's an improper question, so I'm going to sustain the objection.
When you are looking at the investigations that are done into police officer shootings, are there certain policies or practices that are good investigative practices in getting statements from police officers?
Objection. Maybe if we approach you.
Sure.
Let's go back to your opinions, Mr. Noble. Chief, you talked yesterday about how you shouldn't criticize officers on technical or hypercritical in a hypercritical way. How does that apply to this particular case?
Well, in this particular case, when it comes specifically to the issue of this plan that was formed between Sandy, Weimer, Skirch, and Ingram, any expert can find issues with anything. I've written about that in a textbook, that any expert can criticize that you should have had, you should have had a helicopter, you should have had this tool or that tool. And it's not looking for minor mistakes or minor issues or things that could have been done differently or things that could be done better, but whether or not there was just a reckless disregard or indifference to the dangers or consequences of the officer's actions. And so when I conduct an assessment, I'm looking for whether or not there's this reckless disregard. And in my opinion, this plan, where they didn't communicate to anybody else. One of the reasons for communicating, you're setting off a flashbang and it's a loud noise. Officers on the perimeter, if they don't know that's going off.
This is not unresponsive.
Interesting.
Can you talk about why the flashbang was a problem and why they didn't communicate before that time?
This has been asked and answered.
I think he hasn't talked about communication.
Yeah, I'm going to overrule that objection.
One of the reasons you want to alert everybody else is so they know what you're doing, that you're moving in on them. So if that bang goes off, some officer who is positioned some distance away, like the sniper, like Purdue, who's a distance away, he may think that the suspect is now shot at the officers, and he may engage that person, and you may have some bad consequence. So you want to advise your fellow officers. You want to let the supervisors know. Sergeant Fox is a SWAT sergeant on the scene. You want to let them know what your plan is. They've been out there for hours. There's no reason not to let them know.
And the sniper, the SWAT sergeant Purdue that was out to the right of Mr. Boyd on the diagram, did he ever fire?
No.
If this were just minor things or technical things, would you be here testifying in this case?
No.
Thanks, Sean. I'll pass the witness.
Okay. Let me just check with the jury. Is everyone doing okay? Yes? All right. Who would be conducting cross first? Is that Mr. Robles?
I think so, yeah, because he's standing up.
Okay.
Just a moment to rearrange a notebook. I'll be right there.
Your Honor, if you could switch it to defense table, that'd be great.
And on
VGA.
VGA?
Yes, thank you.
May it please the court? Counsel? Mr. Noble. You're here as an expert in police procedures, is that right?
Yes.
And you base your expertise on your own personal experience as a law enforcement officer.
My experience, my research, my study, my education, all those things, yes.
And you began your work as a law enforcer in 1984, is that right?
Yes.
That's when you joined the Irvine Police Department in Irvine, California, is that right?
Yes.
And shortly after being hired as a police officer, you were involved in your own officer-involved shooting, is that correct?
Yes.
And that happened on August the 30th of 1985, is that right?
I remember it was in August. I don't remember the date.
It was a Thursday, wasn't it?
I don't remember.
There was a suspect that was attempting to rob a bank, the Crocker National Bank, is that right?
Yes.
And that's located at 1900 MacArthur Boulevard in Irvine, is that correct?
I think it's 19,000.
19,000. The suspect was in the bank for quite some time.
Yes.
For whatever reason, the employees of the bank were able to keep the suspect from exiting the bank for some time.
I don't remember whether they were able to keep them or I think there was, some discussion of how long it would take to get into the vault, and they were able to delay them.
By that time, the entire bank was surrounded by the Irvine Police Department. Was that true?
Yes.
Now, you positioned yourself in a parking structure in front of the bank, is that right?
Yes.
You were behind a large planter.
Yes.
And then the suspect exited with a hostage, is that right?
Yes.
But the hostage was able to run away from the bank robber, is that right?
At some point, yes.
Yes. Now, the suspect again was surrounded by the Irvine Police Department as he exited the bank.
Yes.
And then the suspect walked past you, is that right?
No, he had walked past me before the hostage was able to run away.
Okay. But the suspect had walked past you at the time the shooting occurred.
Yeah, it was a large concrete planter, and I ducked down so he didn't see me. And simultaneously, there was this was the early 80s, it was the first version of an ATM there. Somebody had pulled in on the wrong side of the road, which I initially thought might be, a getaway car. And it was a lady who wanted to get to the ATM, and so she parked directly in front of me. So as he passed me, all of that was happening at the same time.
But the point, just to be clear, the suspect had walked past you at the time the shooting had happened.
Yes.
Okay. Another officer confronted the suspect at gunpoint, is that correct?
Yes.
And that other officer's name is Al Murray, is that correct?
Yes.
He's a fellow Irvine Police Department officer.
Yes.
Al Murray left cover to confront the bank robber, is that correct?
No, he was behind, there was a large concrete wall that supported the parking structure. So he was using that wall as cover. He was around the wall pointing his gun at the suspect and giving him commands.
And when Officer Murray confronted the bank robber raised his gun towards Officer Murray, is that right?
Yes.
And when the suspect, the bank robber, threatened Officer Murray, you shot him, is that right?
Yes, I did.
And he was shot and killed, is that right?
Yes.
And for that shooting, the Irvine Police Department awarded you the Medal of Valor, is that right?
Yes, they did.
Now, the man who was shot and killed, you remember his name?
No.
Does James Clifford Valentine ring a bell?
Yes.
Okay. Now, did you know that Mr. Valentine was 62 years old when he committed that bank robbery?
Objection, relevance, Your Honor?
If you need to respond, you can approach.
Now, did you know that Mr. Murray was 62 years old? I'm sorry. Did you know that the bank robber, James Clifford Valentine, was 62 years old?
I don't recall whether I knew that. I have no idea. It was 31 years ago. I don't know.
Mr. Ballantyne, the bank robber, had no criminal history,
I have no idea.
and he weighed all of 122 pounds, is that right?
I have no idea.
Now, you would agree with me that Mr. Ballantyne's age and health are not factors when determining whether he posed a danger to you and your fellow officers.
Yes, I agree.
When determining the level of danger that Mr. Ballantyne posed to you and your fellow officers, what matters most is what Mr. Ballantyne was doing at the moment you decided to use deadly force.
Yes, absolutely.
Now, to determine if your use of deadly force was objectively reasonable, your use of deadly force, you must determine if the suspect, Mr. Ballantyne, posed an immediate threat to you and your fellow officers at the moment you made the decision to use deadly force.
Objection, Your Honor. Yeah, I think that's just going farther than the court allowed.
I disagree, so I'm going to allow. You may answer the question if you need it to be rephrased.
Can you please repeat it? I'm sorry.
To determine if your use of deadly force was objectively reasonable, you must determine if the suspect, Mr. Ballantyne, posed an immediate threat to you and your fellow officers at the moment you made the decision to use deadly force.
Yes.
So who the person is that officers use deadly force against doesn't matter as much as what the person does that makes them dangerous. You would agree with that?
Oh, yes, absolutely.
Now, is it true that Mr. Ballantyne was shot several times?
Yes.
He was shot once in the chest, is that right?
I have no idea.
Now, did you know Mr. Ballantyne was shot 3 times from behind?
I would assume that from my angle, that some of the shots would hit him in the left side to the rear, yes.
Now, isn't it true that Mr. Ballantyne was shot once in the lower back?
I have no idea.
You would agree with me that you were armed with a shotgun, is that right?
No.
You weren't armed with a shotgun?
No.
Now, did you have an opportunity to read the autopsy of Mr. Ballantyne?
I've never seen the report.
Did you know that the autopsy report indicates that Mr. Ballantyne was shot in the lower back once?
Objection, Your Honor. I'm afraid now he's talking about hearsay, and something that this expert has never even, this has never even seen. So he's asking hearsay questions of this person.
I asked him if he knew of a document. He said he did, and then I went on.
Hearsay,
Okay,
Your Honor.
well, but he said he didn't know, so I'm going to ask you to move on.
No, but I'm not asking him about, I'm asking him his personal knowledge.
You can ask him his personal knowledge, but not
Okay.
about the document.
Isn't it true that Mr. Ballantyne was shot once in the lower back by you?
I have no idea.
Okay. Isn't it true that Mr. Ballantyne was shot twice in the upper leg, close to the buttock, twice by you?
I have no idea.
Even though Mr. Ballantyne was shot in the back, do you agree that you and your fellow officers' shooting of Mr. Ballantyne was justified?
Yes, absolutely.
Even though Mr. Ballantyne was shot in the back, do you agree with the Irvine Police Department's decision to award you and your fellow officers with the Medal of Valor?
Yes.
And you would agree that just because Mr. Ballantyne was shot in the back, that doesn't
Excuse me,
mean...
Your Honor, he keeps repeating this shot in the back thing, and he said he doesn't know whether he was shot in the back or not. And that hasn't been established. He says he doesn't know anything about
Objection,
that.
speaking objection.
Okay. I'm sustaining the objection. Both of them.
Now, you worked as a police officer, a law enforcement officer, from 1984 to 2011, is that right?
In 2012.
2012, I'm sorry. You worked as a patrol officer for 4 years, is that right?
Yes.
You did not serve as a SWAT team officer during those 4 years.
No, I did not.
Now, you worked as a patrol officer. After you worked as a patrol officer, you were a narcotics detective for 4.5 years, is that right?
Yes.
And you did not serve as a SWAT officer during those 4.5 years.
No, I did not.
Now, after working as a patrol officer and a narcotics detective for 8.5 years, you were promoted to the rank of sergeant.
Yes. At some point, yes.
Before you became a sergeant, you did not serve as a SWAT team officer.
No, I did not.
Although you never served as a SWAT team officer, you became a SWAT team sergeant, is that right?
Yes.
And the Irvine Police Department allowed a sergeant who'd never been a SWAT officer to become a sergeant over SWAT, is that correct?
Yes.
And Do you know how many years Officer Perez served as a SWAT team officer before the 2014 shooting of Mr. Boyd?
No.
Okay. Would you be surprised to learn that Officer Perez had been a SWAT officer for 5 years
Objection.
prior to...
Leading and testifying. Says he doesn't know, and now Mr. Rhodes is putting that in, is testifying about events and also to be on the scope.
I'm going to sustain the objection. He said he doesn't know.
You served as a SWAT team sergeant for 7 years, is that right?
Yes.
And during those 7 years, the Irvine Police Department had a part-time SWAT team.
Yes.
And it's your understanding that the Albuquerque Police Department has a full-time SWAT team.
Yes.
Now, excluding warrant services, during the time you were a SWAT team sergeant for the Irvine Police Department, you had 6 to 7 activations during your 7 years as a SWAT team sergeant.
Somewhere around there, yes.
And during those 7 years that you were SWAT team sergeant, you never responded to a SWAT team call-out involving a mentally ill suspect who threatened the police with a weapon.
That's true.
Now, do you know how many activations the Albuquerque Police Department SWAT team had in 2014?
No.
Do you know how many activations the Albuquerque Police Department SWAT team had in April of 2014?
No.
Would you be surprised to learn
Your
that...
Honor, again, Mr. Rhodes is trying to testify and put evidence in.
Sustain.
Would you agree with me that the amount of work that the Albuquerque Police Department SWAT team is far greater than the work that's done by the Irvine Police Department SWAT team?
I would assume so based on the size of the city, but I have no idea. I've never looked at their numbers.
Now, you've never served as a police service dog handler, is that right?
That's true.
You've never been certified to handle a police service dog.
No, I have not.
And you're not an expert in the field of police service dog work.
No, I'm not.
You served in the Internal Affairs Unit of the Irvine Police Department for 4 years, is that right?
Yes.
And you've never investigated an officer-involved shooting during those years.
That's true.
And you've never investigated an officer-involved shooting during your entire career as a police officer for the city of Irvine.
That's true.
Okay. You never investigated an officer-involved shooting as a homicide detective.
That's true.
You've never been a homicide detective, is that right?
That's correct.
You don't have any expertise on Mr. Boyd's psychological condition, is that right?
No, I don't.
You're not a psychiatrist,
No.
not a psychologist.
No.
You're not a mental health.
I'm sorry, Mr. Rhodes, excuse me. I'm just going to object because this is the same exact examination they did yesterday on Fort Dyer, and so it's repetitive.
I'm going to allow it in cross-examination.
Okay.
Now, during the time that you worked for the Irvine Police Department, you provided some training, is that correct?
Yes.
But you've never taught a class or a course which focuses on the tactics or techniques which an officer should use during a deadly force encounter.
No, that's not true.
Okay. It would be fair to say you never taught a class or course which focuses on the tactics or techniques which an officer should use when dealing with a mentally ill suspect who is armed with a weapon in a deadly force encounter.
No, I've given training on how to deal with deadly force encounters, and that includes dealing with people with mental illnesses and other factors, yes.
Now, do you remember giving an interview?
Yes.
Now, do you remember giving an interview on May the 2nd, 2016?
Yes.
Now, turning your attention to page 45 of the transcript of your interview. And I want you I want to ask you if you remember being asked this question and giving this answer. Question. Now, have you ever taught any class or courses which focus on the tactics or techniques which an officer should use in a deadly force encounter? Answer. No. Do you remember being asked that question and giving that answer?
I don't recall, but I'm sure that the transcript's correct.
Okay. So is it true that you've never taught any class or course which focuses on the tactics or techniques which an officer should use in a deadly force encounter?
No, that's not true.
Okay, so when I asked you that question in the interview, you were less than truthful with me. Is that right?
No, perhaps I misunderstood the question or I didn't recall, but I certainly have taught classes, particularly like on simunition classes on how to tactically engage somebody. So whether the class was, did I teach a class specifically that was the topic? No. Did I teach classes where that material was part of it? Yes.
Okay. So let me ask you if this question will seem confusing to you. Question. from page 45, line 4. Now, have you ever taught any class or courses which focus on the tactics or techniques which an officer should use in a deadly force encounter? And you answered no. Was that a confusing question to you?
I don't know what I was thinking at the time, but I've given my explanation.
Okay. Now I'd like to talk to you about working as a police officer in the city of Irvine. You would agree with me that working in the city of Irvine, a very affluent community, is different than working as a police officer in the city of Albuquerque.
I'm sure it is.
Okay. Do you agree that the economy of the city of Irvine is very different from the city of Albuquerque?
Oh, I'm sure it is.
Okay. And isn't it true that the city of Irvine has a population of approximately 240,000 people?
It does now, yes.
Okay. And the city of Albuquerque, did you know, has a population of 560,000?
No, I don't know.
So it's fair to say that the city of Albuquerque is only twice as big as the city of Irvine.
Objection, Your Honor, I think you said you didn't know the answer to that question.
Overruled.
Now, isn't it true that the city of Irvine is corporate headquarters for 13 companies that have revenue in excess of $1 billion?
I have no idea what the revenue is. I mean, it's certainly home of a lot of major corporations, yes.
And did you know that the state of New Mexico only has one corporation, P&M, which has revenues in excess of $1 billion?
Objection, Your Honor, the lawyer then is testifying and putting in information in the record.
With regard to the second half of that question, after P&M's estate.
Now, it would be fair to say that the city of Irvine's economy and business environment is significantly better than that of Albuquerque.
I've never taken a look and done comparisons. I wouldn't be surprised about that, but I don't know.
You would agree with me that residents of the city of Irvine are, for the most part, much wealthier than those in the city of Albuquerque.
That wouldn't surprise me. Have I done any kind of study? Have I looked at the demographics? No.
Did you know that according to the U.S. Census Bureau, that the average median household income in the city of Irvine is $91,000?
Excuse me, Mr. Robles. Objection. Hearsay, Your Honor?
Sustained.
Did you know that the average income earned by a household in the city of Irvine is twice that in the city of Albuquerque?
Excuse me, Your Honor, again, I think this is hearsay, and I don't think you would know that.
The way it's asked, I'm going to allow it, so overruled.
Did you know that the average household income earned by a family in the city of Irvine is twice that in the city of Albuquerque?
No, I've never looked at the census data.
Did you know that the average value of a family home in Irvine is 3.5
Excuse me, Your
times?
Honor, I'm going to interrupt again. I think all this data from Google or wherever it's gotten, it's all hearsay information, and it's just Mr. Robles testifying.
Your Honor, I have a good faith basis.
Let me have you prove. Thank you. You may be seated. You may take a break as well, just don't discuss your testimony during the break. And, yeah, we're in recess.
11:45, Judge?
Yes. Oh, well, I think I said 10.
10:45. Perhaps 10:45.
10:40. Well, I think I said 10 minutes, so between 10:40 and 10:45. And maybe you could look at the screen, Mr. Audience.